This video is for you, the parent whose child is involved in a child protection proceeding. It will also be helpful to other persons who have an interest in your child's welfare.
This is an emotional and confusing time for you and your child. To help you understand Minnesota's child protection system, this video will identify the people who will be involved in your child's case and who will be in the courtroom. Explain your legal rights and responsibilities. Describe the juvenile court process, including the types of hearings that you may be required to attend and what happens at a typical hearing. Explain how the juvenile court process may affect you and your child and what will happen after court. Emphasize that your child's best interests are at stake and timely resolution of the problems causing risk of harm to your child is important to the healthy development of your child.
My name's Denisa. I'm 46 years old, and I've been clean 12 years. I have 5 children, and it was extremely difficult to parent them alone, and then having to add the difficulties of trying to manage a drug addiction made it even harder. In early 1990, I believe, my mom called child welfare and did a report because I'd left the children at home alone. It wasn't the first time I had left them alone, and it had become quite dangerous for them. And in my addiction, I didn't understand that what I was doing to my children was very harmful.
My name is Tiffany, and I am the mother of 4 children. In 2003, my children were 12, 16, 1, and I had a newborn son, which is what brought me to be involved with child protection. I had been trapped in the horrors of alcoholism and addiction for all of my life, and unfortunately was unable to quit using while I was pregnant, and because of the birth of my child being under the use of drugs, child protection was brought into my life, and my children were removed from my care. In a 60-day period, I had regained custody of my children, but I continued to drink and use drugs and manipulate the system, which led to an arrest in 2004 where my children were again taken away from me. And I was placed in jail at this time and believed that I would never see my children again.
The purpose of juvenile court is to provide safety for your child and services for you and your family to assist you in resolving the problem that may be causing risk of harm to your child. You have received a petition alleging that your child is in need of protection or services. This is also called a CHIPS petition. A CHIPS petition is a document that alleges facts about your child's circumstances and the legal basis for a child protection case. A CHIPS petition also asks the judge to issue an order to protect your child.
In the beginning, I thought it was all about taking my children away because I was a bad person.
You're their parent, and children want to and need to be with their parents, but they also need to be in an environment that's safe, that's nurturing, you know, and that's happy and healthy.
When my children were removed from my care, I didn't believe there was any hope of them being returned to me. The fear, the anxiety, the feeling of wanting to just run away from it all, because I didn't believe that I would get them back anyway. And I remember feeling that I was just going to run. And I remember the first day in court and not believing that anyone was really on my side, that they were just here to let me know that I wasn't going to get my children back.
This is a typical courtroom. Courtroom rules require that all hats, caps, and coats must be removed before going into the courtroom. Food, beverages, and chewing gum are not allowed in the courtroom. All cell phones and pagers must be turned off.
All rise. Juvenile court is now in session. The Honorable Robert Birnbaum presiding. Please be seated.
Several people sit in the front of the courtroom at the bench.
Good morning, counsel and parties. Please identify yourselves for the record.
The judge sits behind the bench in the front of the courtroom. The judge will listen to what the parties or their attorneys have to say and may ask questions. The judge will make decisions about what happens regarding you and your child. The court reporter sits near the judge. The court reporter records everything said in the courtroom. Everyone in the courtroom must speak loudly enough for the court reporter to hear. Only one person may speak at a time.
This hearing is in the matter of the welfare of the child of Rick and Karen Jones, case number J902-68547.
The court clerk also sits near the judge. The court clerk takes notes for the judge, schedules the next hearing, and may prepare orders at the direction of the judge.
Other people will be involved in your case and may be present in the courtroom. The county attorney is a lawyer. The county attorney represents the social services agency and explains the case to the judge during the hearing.
Good morning, Your Honor. I'm Susan Harris, Assistant County Attorney on behalf of County Social Services.
The social worker is from the county social services agency. The social worker will continue to gather information about you and your child, develop a case plan designed to resolve the problems causing risk of harm to your child, and continue to work with you and your child after the hearing today.
Good morning, Your Honor. I'm Elaine Hutton, Child Protection Social Worker.
A guardian ad litem, also known as a GAL, is appointed by the judge as an advocate for the best interests of your child. The guardian ad litem will gather information about you and your child and make recommendations to the judge about what is in your child's best interests.
Good morning, Your Honor. I'm Vic Walker from the Guardian Ad Litem program.
As your child's parent, you will be in the courtroom for the hearing.
Hello, I'm Karen Jones, Mike's mother.
Good morning, Your Honor. I'm Pat Zenner, Assistant Public Defender. I represent the mother, Karen Jones.
As your child's parent, you may be represented by an attorney who will also be present in the courtroom.
I'm Rick Jones. I'm Mike's father.
Good morning, Your Honor. My name is Patrick McGee, Assistant Public Defender. I'm the court-appointed attorney for the father, Rick Jones.
Your child may also be present in the courtroom, depending upon the age of your child and the circumstances of the hearing.
Hi, I'm Mike Jones. I'm 11 years old.
Good morning, Your Honor. My name is Gail Chang-Boer. I am the court-appointed attorney for the child, Mike Jones, who's present.
Your child may be represented by an attorney, depending upon your child's age and other factors considered by the judge. Your child's attorney may also be in the courtroom.
Other people may be present in the courtroom. These people may include your child's non-custodial parent, foster care parents, grandparents and other relatives, an Indian tribe representative if your child is an Indian child, and others who have a relationship with your child. Child protection hearings are open to the public, so people you do not know may also be present in the courtroom audience.
As a parent, you have the following rights. The right to receive notice of the date and time of all hearings. The right to be represented by an attorney. If you cannot afford an attorney, you may ask the judge to appoint an attorney to represent you. The judge will appoint an attorney to represent you if you qualify. To find out if you qualify for an attorney, you must complete an application and submit it to the judge. You may obtain an application from court administration. The right to be present at all hearings. The right to conduct discovery. Discovery means the right to receive copies of your social services file, medical records, and other information and reports written regarding you and your child. It also means the right to receive the names of any witnesses who may be called by others to testify. The right to bring motions before the judge.
Please approach, Ms. Zenner.
A motion is a written document asking the judge to order something you want to happen regarding you or your child. The right to participate in settlement discussions and agreements. The right to subpoena witnesses to come to court to testify on your behalf. The right to make an argument before the judge in support of or against the petition. The right to present evidence supporting your side of the case. You may present witnesses or written documents. The right to question or cross-examine witnesses called by other people involved in this case. The right to request review of the judge's or referee's decision. If you want to know your options, you should consult your attorney.
As a parent, you have the following responsibilities. You must come to court when you are notified to do so. If you fail to come to court, the hearing may still take place without you, and the judge may still make decisions about your child and you. This means that even in your absence, the judge may permanently remove your child from your care or terminate your parental rights. You must follow all court orders. You must follow your case plan if it is approved by the judge. The case plan will be developed by you, your child if your child is old enough to participate, the social worker, the GAL, your child's tribe if your child is an Indian child, and others. Its purpose is to identify the problems causing risk of harm to your child and what you and others will do to resolve those problems. The focus of the case plan is the best interests of your child. You should work with your attorney. If you are represented by an attorney, you should address all questions and comments to the judge through your attorney.
When I originally started working with my child welfare worker, it was almost like Clash of the Titans because I felt like she was the enemy.
In the beginning, when I was brought in to make a case plan, I felt so overwhelmed, like this would not be possible. How am I ever going to be able to accomplish all these things?
Then I had this person, this stranger, that was telling me, you need to do this and this and this, and this is how we're going to get your family back to you. Sometimes I thought it was unreasonable.
And having my children and getting them to school and working and going to treatment and aftercare and meetings and I didn't think that any of this would be possible for me to achieve.
Even though things seemed to be really difficult and really hard, I finally just found a place, tried to find a place with the child welfare worker to say, okay, I understand you want me to do this, and if I need to do these things, then I may need assistance doing some of these things. And can you get me the assistance that I need? Can you set up transportation if I need transportation, because I don't have a vehicle? Can, you know, whether that was taxis, bus cards, or however.
There are many types of juvenile court hearings that you may be required to attend. These include the following: an emergency protective care hearing. This is also known as an EPC hearing. An admit-deny hearing. A pre-trial hearing. A trial. A disposition hearing. A review hearing. Or a permanent placement determination hearing.
You may be in court today for an emergency protective care or EPC hearing if your child has been removed from your care. At an EPC hearing, the judge will decide where your child will live until the next court hearing. The judge may decide to return your child to you or to your child's other parent with certain conditions or requirements, or place your child with a relative or important friend who must become licensed to provide foster care, or place your child in foster care or in a shelter. If you have had sufficient time to review the CHIPS petition and talk with your attorney,
you may be asked to admit or deny whether the facts alleged in the petition are true. You or your attorney will have the opportunity to let the judge know where you want your child to live and what you want to happen in this case. You or your attorney will also have the opportunity to let the judge know if you want other people to come to court to testify on your behalf, or if you want to submit any written evidence about this case.
You may be in court today for an admit-deny hearing if this is your first appearance in court. At this hearing, you will be asked to admit or deny whether the alleged facts in the petition are true. If you deny that the alleged facts are true, the judge will set another hearing called a pre-trial hearing or a settlement conference. If you admit that alleged facts are true, you will be placed under oath and will be questioned about the facts and the legal basis of the petition. The judge will then issue a disposition order, either at this hearing or at a disposition hearing to be held later. The disposition order tells you what you must do to resolve the problems that are causing risk of harm to your child.
If a pretrial hearing is necessary, at that hearing, you, your attorney, the county attorney, the social worker, the guardian ad litem, your child's attorney, and the Indian tribe representative, if your child is an Indian child, will try to reach an agreement about what should happen regarding you and your child. If you are unable to reach an agreement about what should happen, the judge will set the date for a trial.
If a trial is necessary, the county attorney will try to prove the facts alleged in the petition. The county attorney will do this by calling witnesses to testify and by submitting written documents. You or your attorney may also call witnesses to testify on your behalf about the alleged facts and legal basis in the petition. You also have a right to submit written documents. The guardian ad litem may also call witnesses and submit written documents. You and your child may also be called as witnesses to testify. After the judge has heard all the witnesses and read all the documents submitted by the county attorney, the GAL, and you or your attorney, the judge will make a decision and issue an order about what should happen. Before issuing an order, the judge may need some time to consider the witness's testimony, other evidence, and any written briefs.
The judge must make a decision about the CHIPS petition. The judge may dismiss the petition if there is not enough evidence to support it. The judge may decide your child is in need of protection or services and issue an order with such an adjudication. Then, the judge may order you, your family, and other family members to do certain things to resolve the problems causing risk of harm to your child. For example, the judge may order you to find appropriate housing, attend counseling, attend parenting classes, or complete chemical dependency treatment. The judge may also order the social services agency to provide services to your child and you to help you resolve the problems. Remember, you must follow your case plan and do what is ordered by the judge. If you don't follow your case plan, or if you don't do what is ordered by the judge may permanently remove your child from your care or terminate your parental rights.
Instead of keeping these problems to myself and trying to figure out how I was going to solve them, that if I would just go to my worker and bring them to her, that they would help me resolve these things. And the transportation problem got solved. And, you know, things that finding a job and having to put in so many applications and all these problems that I thought I wouldn't be able to achieve once I began to actually ask for the help and to know that they're truly there to help me. And I don't have to do it alone. It was really a turning point.
As hard as it was in the beginning, once I figured out that she really wasn't my enemy, we may have had some personality differences, that she really wanted my family to be back intact, then we were able to move forward.
Had I kept on with the belief that the system was not here to help me, that I wouldn't have been able to move forward and receive the help that they are truly there to give.
After today, the social worker and guardian ad litem will continue to be involved with you and your child. If your child is an Indian child, your child's tribe will also be involved in decision-making about your case. The social worker will help you find services that will resolve the problems that are causing risk of harm to your child. The social worker will also help you follow your case plan. The guardian ad litem will visit you and your child and, keeping your child's best interests in mind, will monitor the progress of the case. After today's hearing, you should keep your attorney informed of any changes in your or your child's situation. If your child is placed in foster care, you must appear in court at least every 90 days, so the judge can review your progress on your case plan. You must attend all hearings unless you are excused by the judge. If it appears that the problems causing risk of harm to your child have been resolved, your child will be returned to your care, and the case will be dismissed from court.
The law states that you have only a limited amount of time in which to resolve the problem that is causing risk of harm to your child.
If your child has been removed from your home and is not returned to your home within 12 months, the law states that the judge must hold a hearing to make a decision about the permanent placement of your child within 12 months of the date your child was removed from your care. This means you have only 12 months to resolve the problems causing risk of harm to your child. If your child is under 8 years of age and has been removed from your home, the law says that within 6 months of the removal, the judge must hold a hearing to review your progress on your case plan and whether you are having regular contact with your child. If you are not making progress on your case plan and maintaining regular contact with your child, the judge may ask the county to file a permanency petition so that the judge can make a decision about the permanent placement of your child. If you do not resolve the problem within the time allowed by the law, the judge may permanently remove your child from your care and may terminate your parental rights. The entire juvenile protection system is designed to promote the best interests of your child and to keep your child safe.
We hope this video has helped you to understand the people who will be involved in your child's case and who will be in the courtroom, your legal rights and responsibilities, the juvenile court process, including the types of hearings that you may be required to attend and what happens at a typical hearing, how the juvenile court process may affect you and your child, and what will happen after you have been in court. That your child's best interests are at stake, and timely resolution of the problems causing risk of harm to your child is important to the healthy development of your child.
There will be hearings in the future. Mr. and Mrs. Jones, you must come to those hearings. If you do not come to those hearings, the court can still issue orders, including ordering that your child be permanently removed from your care or that your parental rights be terminated.
Your Honor, I've prepared the scheduling order, and I am now distributing it to all the parties and their attorneys. The next hearing in this matter is scheduled 90 days from today.
Thank you. This matter is now adjourned.
I found that the Juvenile Court and Child Welfare Agency had our best interests at heart. The road back was not easy, but it was well worth it.
The courts and the social services kept me hopeful that what they were doing was to help me and to help my children. And that has proven to be exactly what has happened for me.
I have 5 grandchildren. And I think about, my life had not come together, then that's a whole generation that I would have known nothing about. So when I think about the work of recovery, the work of allowing the court systems and the child welfare system to help me to be better, I don't think about it so much as what they did to me or what they want me to do, but I think about it now in a generational thing, that the help that I received affected generations and will continue to affect generations to come.
And I'm so grateful to know today that those thoughts and those fears and all that confusion that was going on with me is not what happened, because I continued to ask questions and to follow the case plan. Things turned out like I never dreamed. Today I have a beautiful family. And I never thought that we were going to be together again at one time. And I hope that I can give somebody else the hope to know that their family can be together again too.
Your child needs a safe, stable, permanent environment in order to thrive and develop in a healthy way. Time is important to your child's healthy development. It is in your child's best interest for you to quickly resolve the problems causing risk of harm to your child. Please remember that your attorney or your social worker should be able to answer any other questions you may have. Thank you.